Hello, magandang hapon po sa inyong lahat. Welcome po sa webinar natin. Please feel free to introduce yourself sa ating chat box. We'll start in a moment. Magandang hapon po sa lahat ng participants natin. Simula na po tayo maya-maya. Kung meron po kayong mga questions, please feel free to type them in our chat box. Bibigyan daan namin mamaya sa open forum. Magandang araw po sa inyong lahat and welcome to Duterte's Crimes Against Humanity, Rendering Justice Through the ICC. Ang webinar na ito ay hatid sa inyo ng Movement Against Tyranny, Rappler's MovePH, Rise Up for Life and Rights, Free Leila de Lima Movement, at Karapatan Alliance for the Advancement of People's Rights. Ako nga pala si Josa de Inla ng National Union of People's Lawyers, ang inyong tagapagpadaloy ngayong araw. The recent move of the International Criminal Court or ICC prosecutor Fatou Bensouda to seek ICC authorization to conduct an investigation on President Rodrigo Duterte's crime against humanity of murder has raised hopes of making Duterte and his officials accountable for the drug war killings. Yan ang pag-uusapan natin ngayon. Ang mga katanungang ating sasagutin ay exactly what does the communication against Duterte allege and why is an investigation by the ICC prosecutor in order? What are the next steps for the ICC? What role do human rights advocates, social movements, and civil society organizations play in ensuring that Duterte is prosecuted and punished? Meron tayong inimbitahang apat na tagapagsalita ngayong hapon para bigyan linaw ang mga issue na ito. So I'll jump right in and introduce our first speaker. He will discuss People of the World versus Duterte, the crime against humanity of murder. Here is the chairperson of the National Union of People's Lawyers, Attorney Neri Colmenares. Go ahead, Attorney Neri.
Magandang hapon po sa inyong lahat. Maraming salamat sa imbitasyon ng mga organizers ng forum na ito for the timely discussion nitong topic na ito. I have a PowerPoint kung pwedeng ma-share. Yes, before I start, ang nabigay sa akin na topic yung naka-complaint na naka-file sa Sa ICC, ang tawag doon may mga communications na final. Pero ang matidiscuss ko is yung kaso na hinanda namin para sa pamilya ng mga biktima at sa Rise Up. Hindi ako magdi-discuss ng ibang communication kasi hindi ko alam no kung ilan ang nag-file. Sigurado may nag-file na iba. Kaya lang because confidential sila, hindi ko rin alam ang laban noon. Hindi ko na rin ma-discuss yung kay Attorney Jude Sabio, yung naunang nag-file way back in 2017. So ang i-discuss ko, yung hinanda ng NUPL bilang mga abogado ng mga biktima ng mga pamilya ng biktima ng EJK at Rise Up. So, but before we go to the actual complaint and the decision of the prosecutor, just a short background ng International Criminal Court. First slide, please. So, ang International Criminal Court, isang permanent court yan kasi ang mundo, parang nagsabi ang mundo, bawat na lang ba atrocities, gagawa tayo ng tribunal. Nung panahon ng World War II, nag-Nuremberg trial para sa mga German, sa Nazi. No? Merong Tokyo Tribunal din para sa mga Hapon ng World War II. Nung nangyari ang genocide sa Rwanda, nagkaroon na naman ng tribunal for Rwanda. At nung nagkaroon naman ng giyera sa former Yugoslavia, may tribunal din doon. So why not a permanent court? Para lang naman na every time na may atrocities, mabilis na ang reaksyon at response. So matagal itong nangyari kasi maraming bansa ayaw pumirma kasi ang nakasanayan naman talaga natin yung ating kung ang krimen nagawa sa bansa mo, ikaw ang mag-try niyan. Pero na-recognize na rin ng international community in the end na importante nga na may isang korte na ganyan just in case na hindi ma-prosecute o ma-investigate ang mga heinous crimes. No? Kaya nag-agree ang lahat in the end, including the Philippines, na pumasok sa International Criminal Court at na-recognize natin ang kahalagahan ng isang korte na mag-jurisdiction kumbaga sa mga kriminal dito sa atin na hindi napoprosecute o na-investigate. Apat ang krimen sa ICC, genocide, crime against humanity. Ang tawag dyan sa traditional sense, ito yung mga human rights violation. In the traditional sense. At ang pangatlo ay ang war crimes. Ito yung mga violations ng international humanitarian law katulad ng Geneva Conventions sa panahong may giyera. At saka yung apat is yung aggression. Isang dahilan yan bakit hindi sumama yung US sa ICC dahil tingin ng US maraming kaso sa kanila for the crime of aggression. So next slide please. I have 10 to 15 minutes. So I'll probably do this fast. No? So ang ICC na-ratify yan ng 123 countries ngayon. You will not believe it. The one who signed the Rome Statute was President Joseph Estrada on December 28, 2000. Alam mo, December 31, deadline na ng signing noon. At pag hindi siya nag-sign noon, magiging accession na lang yung ating ibang, mas komplikado yung pagpasok natin. So, mabuti nakahabol siya 2 days na lang halos before the deadline. May mahiwalay na kwento kung paano nag-sign si Estrada, but that's for another forum. Kaya lang, ang pumalit sa kanya a few days later, actually 1 month later, na overthrow siya, si Gloria Arroyo. Ayaw ni Gloria i-submit sa Senate for concurrence yung Rome Statute, kaya tumagal ito. Isang dahilan siguro, ang daming human rights violations sa panahon ni Gloria. So, pag-upo ni President Aquino noong 2010, siya ang nag-transmit sa Senado in 2011 at doon nag-concur ang Senado sa Rome Statute at naging effective na member tayo ng ICC. Kaya 2011 ang simula ng prosecutor. Kasi before that, bagamat we signed in 2000, hindi tayo naging full member ng ICC until 2011. Okay. May 4 na kaso ng pag-withdraw sa ICC, yung South Africa, nag-withdraw sa ICC pero dineklara ng Korte Suprema nila na unconstitutional ang withdrawal for lack of legislative sanction. No? Ang Burundi nag-withdraw pero ang sabi ng ICC doon, may yung mga kasong makasampa na sa iyo. Kahit mag-withdraw ka pa, tuloy yun ha. Otherwise, useless ang ICC kasi ang gawin lang pala ng mga bansa pag may kaso, withdraw. Hindi pwede. So, natuloy ang kaso ng Burundi. Si Gambia nag-withdraw, ang presidente nila nag-withdraw sa ICC, pero natalo siya a few months later sa election. So yung bagong presidente, binalik sila. Binalik ang Gambia sa ICC. niretract yung withdrawal. Kumbaga. Ang Philippines, nag-withdraw effective ito ng March 17, 2019. Next slide, please. So, ang kaso na na-file ng mga kaanak ng mga biktima at ng Rise Up ay ang crime against humanity. So, ang crime against humanity, ang requirement niyan, tingnan niyo yung sa taas. Yung sa taas, yun ang requirement dyan. Widespread or systematic attack. Widespread, ibig sabihin sa buong malawak na pag-atake, no? Na patayan, or kaya systematic, meaning it's a matter of policy kasing systematic. Pare-parehong modus operandi na parang may nagdidikta sa taas na paano gawin itong mga pagpatay. So yun ang first element. Pangalawa, it's directed against any civilian population. Dapat civilian yung inaatake. At pangatlo, with knowledge of the attack. So i-establish a trial, yung tatlong yan, na may alam ang perpetrator syempre ng atake. So yun. Maraming charges dyan under the crime against humanity, murder at iba pa. Ang final ng NUPL together with the victims, the families of the victims, dalawa lang. Murder and yung panghuli, other inhumane acts. Okay, so dalawa lang ang pinili namin out of the many other crimes sa ilalim ng crime against humanity. Next slide, please. Ngayon, ang unang charge doon sa complaint na yon ay una, murder. Ang sabi sa complaint, widespread and systematic attack against civilians in the form of murder of thousands of civilians prescribed under Article 7, Paragraph A of the Rome Statute through his publicly pronounced policy against drug suspects kay President Duterte yung HIJA. Kasi siya ang kinasuhan talaga namin through police directives, Oplan Double Barrel, Tokhang, Oplan Double Barrel Alpha, Oplan Double Barrel Reloaded, etc. Resulting in the death of at least 4,410 persons. So lahat yan ay binilang namin, 4,410 at the time of filing. Hindi na kami pumunta doon sa 25,000, 30,000 kasi masyado nang magdidebate pa doon kung tama o hindi. At least itong 4,410, ito yung ina-admit ng PNP sa website nila na real numbers. Okay, lahat ng mga opla na yan naka-attach sa complaint. Kaya talagang well-documented yung complaint, pati yung mga sworn statements, affidavit ng mga complainants, mga witness, etc. Kaya medyo kompleto kung todos yung communication na na-file ng kaanak. Next slide, please. Dalawa lang naman ang crime na final namin. Ang una ay murder, nakita nyo na. Ang pangalawa, yung inhumane acts. No? Widespread and systematic attack against civilian in the form of inhumane acts, intentionally causing great suffering, etc., etc. So, dalawang crime yan ang final namin under the crime against humanity provisions. Next slide, please. So, nung na-file na yung kaso na yan, ito ngayon ang desisyon ng prosecutor. Siguro palalimin pa ito ng ibang speakers, hindi ko alam kung may magdi-discuss nito. Pero ito yung ilang excerpts. Basahin ko na lang para mas madali. Sabi ng prosecutor, there is reasonable basis to proceed with an investigation in relation to crime against humanity of murder and other crimes. So medyo dalawa yung tukoy niya doon. Una, murder, at pangalawa, yung other crimes niya, other inhumane acts. So medyo masaya kami na yung dalawang crimes na nilagay namin sa complaint or cold communication ay na-recognize ng prosecutor sa decision niya. Ang sabi ng prosecutor, which are sufficiently linked to the war on drug campaign committed from at least July 1, 2016 or March 16, 2019. Bakit July 1? Kasi yun yung araw na nag-office si President Duterte as president. No? Tapos may request ang prosecutor with a request that the 2011 to 2016 events in Davao be included in the investigation. So ang covered nito ay July 1 nga, 2016. Yung sa complaint na final ng kaanak ng Rise Up, July 1, 2016, hindi kami nag-deadline kasi at that time hindi pa naman naka-withdraw ang Pilipinas. Hindi namin kinover yung Davao. So that's the first. Ang second, these extrajudicial killings perpetrated across the Philippines appear to have been committed pursuant to an official state policy of the Philippine government. So ang in-establish dito ng prosecutor, yung systematic kasi may official policy ang gobyerno sa EJK. At in-establish niya lang dito na rin dito ang widespread kasi perpetrated across the Philippines. So finulfill niya ang dalawang requirement ng crimes against humanity. Next slide, please. Ang sabi pa ng prosecutor, available information indicates that the war on drugs crimes were committed by both state actors, particularly members of law enforcement and other perpetrators, vigilantes, alleged to have acted in coordination with state actors. Ibig sabihin ng prosecutor dito, dalawa. Ang una, yung state actors, yung mga police at mga public officials na nag-conduct nito. Pero sabi niya, may mga individuals or private citizens na vigilantes pero they were acting in coordination with state actors. In fact, sabi ng prosecutor sa ilang parts ng desisyon niya, minsan nga binabayaran pa sila ng police para mag-EJK. So yun. Ang pang-apat na excerpt na kinuha ko, those information also indicates that the majority of the crimes directly attributable to state actors were committed by members of the PNP. Dito nag-specific siya ng konti na. In some cases, jointly with members of other law enforcement agencies and the AFP. So medyo, there was a time kasi na nag-join ang AFP doon sa anti-drug campaign. And with the participation of various other state actors, including authorities from the national and local levels. So yung extent na ngayon, mula sa national hanggang sa lokal. In fact, may mga instances dyan sa decision niya na nagpo-point out siya sa local. Binabanggit niya paminsan barangay. So medyo grabe, comprehensive ang investigasyon na ilulunsad ng prosecutor the moment na ma-approve yung kanyang request. Next slide, please. Yung panlimang excerpt na kinuha ko sa desisyon, medyo nag-specific na siya, lalo pa. Sabi niya, this includes the two PNP Director Generals in charge of police operations during the relevant period, namely Ronald de la Rosa and his successor, Oscar Albayalde. As well as, ito na ngayon, below them, the directors of the Anti-Illegal Drugs Group, kasama na siguro dito yung iba't ibang mga anti-drug agencies ng gobyerno na isasama sa investigasyon, and the Drug Enforcement Group. No? So yung dalawang unit na yon. As well as the PNP regional, provincial, and city-level directors in charge of coordinated operations on the ground. So hinilera niya na yung i-include sa investigasyon mula sa Chief PNP pababa sa city-level directors. So yun yung sinabi niya doon. And lastly, doon sa civilians, may sinabi siya, various officials falling under the DILG also contributed to relevant operations. So ma-include dito, hindi lang yung uniform personnel, kundi pati civilians because of the inclusion of DILG at yung subordinates niya, LGUs yan. LGUs ang tinutukoy niya dyan. So, yun yung mga particularities. Next slide, please. So, ang response ni President Duterte dito ay ICC has no jurisdiction because we have withdrawn from the ICC. Siguro sa open forum o kaya baka i-discuss ni Dean Agabin o ni Dean Tony yung point na yan later. Wala na akong oras. So the case is not admissible because it violates ICC's complementarity since the Philippine justice system is willing and able to investigate and prosecute. Yun, i-discuss din yun siguro later on. Pero isa lang masabi ko dyan, wala talagang mangyari sa mga kaso dito kasi other than the fact na ang bagal-bagal ng mga kaso at alam ng mga biktima yan na hindi talaga interesado ang kapulisan at ang gobyerno na mag-imbestiga seryoso at mag-prosecute, si President Duterte mismo nag-claim ng presidential immunity. So the justice system is unable to investigate and prosecute. Wala talaga siyang kaso ngayon. This is politically motivated. Hindi na siguro ito yung sagot ni Duterte, politically motivated. Weird talaga yun. Wala namang kinalaman ng ICC sa election sa 2022. Ano naman yung dahilan niya. Anyway, probably sa open forum yung mga kasagutan dyan o ibang speakers. I'll just go to the last slide. Last slide. Next slide please. Hindi ko na i-discuss yan. Mamaya na yan. Okay, next slide please. Next pa. Last slide na lang. Yan. Yung last slide lang, i-discuss rin siguro yung Dean Agabing ito. Pero I'd just like to end on that note. Ngayon, nakapending na ang desisyon ng prosecutor, humihingi siya sa ICC na ibuksan na yung investigasyon. So ano na ang role ng mga complainants katulad ng mga biktima ng Rise Up, biktima ng EJK at ng Rise Up na nag-file ng complaint? Ano naman ang papel ng mga biktima na hindi naka-file ng complaint? Well, may chance kayo to participate. So pending the approval of the investigation, at least 30, at most 30 days so far, within 30 days from notice, victims may register and file with the ICC through the Victims Participation and Reparation section their plea that the investigation for the crime against humanity for murder and other crimes be open. So pwedeng sumulat ng mga biktima sa ICC, mag-register muna kasi kailangan mag-register ka na we support, halimbawa, we support the opening of the investigation. Of course, yung siguro may pakawala din sila President Duterte na magsabi na do not open the investigation. But para sa mga biktima talaga, that's their chance to participate. Ang last point, pag halimbawa ma-decide ng ICC na buksan ang investigasyon as requested by the prosecutor, may kailangan rin ang mga biktima ulit mag-file at mag-register to apply for participation in the potential trial. Ibig sabihin, kung sakaling magka-trial, gusto namin mag-participate, kailangan yon para ma-record ka na willing ka mag-participate and possible reparation. Kung may reparation man o bayarin si President Duterte doon sa ginawa niyang mga krimen. So yun, may papel ang mga biktima dito sa ICC at hindi siya parang wala na siyang papel kasi prosecutor na nagpo-prosecute. So yung end statement ko siguro is this. Napakahabang panahon, lumapit ang mga kaanak sa amin sa NUPL, nagtatanong ano pwedeng magawa namin. We always tried our best to help them. Pero hindi talaga kakayanin yung ganitong ka-attitude ng Estado na ang bigat-bigat ng kanilang mga puwit, kumbaga, para mag-imbestiga at mag-prosecute. In fact, ngayon pa lang naghihingi ang DOJ ng mga records. Paano nga naman prosecute in the last 5 years? Wala ka palang record ng mga nangyari doon. And of course, si President Duterte immune from suit kasi may mga kaanak na gusto siyang pailan ng kaso. Sabi namin, unfortunately, he claims presidential immunity. Siguro ang nangyari sa ICC ngayon is magbigay talaga ng pag-asa sa marami na darating ang panahon ng lahat ng krimen, lahat ng atrocities na ginawa sa ilalim ni President Duterte at sa Duterte administration ay magkaroon ng liwanag at magkaroon ng hustisya. Maraming salamat po. Magandang hapon sa inyong lahat.
Maraming salamat, Attorney Mary. Maraming salamat sa pagtalakay na ibig sabihin ng crime against humanity at sa pagpapaliwanag kung bakit yung mga EJ case o yung pagpatay sa ilalim ng drug war ay maituturing na crime against humanity. Kaya ang sunod na pag-uusapan natin ngayon, paano ngayon mapapanagot si President Duterte at ang kanyang mga opisyal para sa mga krimen na ito. So ipapakilala ko na ang ating susunod na speaker to discuss how the ICC can make Duterte accountable for his crime. Here is former UP Law Dean Pacifico Agabi. Good afternoon, Dean. Go ahead po.
Good afternoon, Yosa, and magandang hapon po sa kanilang lahat. Let me take up from where Neri ended. At ang tanong po ano mangyayari ngayon pag may reasonable basis for an investigation? Ang sagot po dyan ay yung recommendation ng prosecutor for an investigation ay i-review po ng isang body ng judges sa ICC. Ang pangalan ay yung pretrial chamber. Yung pretrial chamber po consists of 3 judges. At ang function po nito ay i-review yung recommendation ni prosecutor kung talagang mayroong reasonable basis or not. Kaya po medyo matagal-tagal pa yung rota upang magkaroon ng trial. By analogy, I think that the procedure in the ICC ay similar po sa procedure ng criminal law dito sa atin eh. Kaya po yung ano ang analogous doon sa recommendation ng prosecutor for an investigation. Ito po ay para ito ragang report ng police eh. In other words, mayroong nangyaring krimen, nag-investigate ng police, nalaman ng police na mayroong murder, alam din nila kung sino ang mga persons of interest, kaya po gumawa sila ng recommendation at itra-transmit sa piskalya. Kaya yung piskal ngayon, i-review yung recommendation ng police. Ang difference po nito sa ICC imbes na diretso sa prosecutor, meron pong pre-trial chamber. Yung pre-trial chamber, ito po yung parang supervisor ng prosecutor. Kung talagang tama yung ginagawa ng prosecutor o hindi. Kaya po ngayon, i-review na ng pre-trial chamber yung recommendation ng prosecutor at pagkatapos sasabihin nila sa prosecutor, okay, talagang sa review namin mayroong reasonable basis upang magkaroon ng formal investigation. Ito po ang tinatawag na preliminary investigation. Yung investigation ng una ni Prosecutor Basoda ay tinatawag na preliminary examination. Ito ay para yung investigation lang ng mga pulis. Kaya po ngayon, pagsasabihin ng pre-trial chamber na merong reasonable basis talaga, then sasabihin sa prosecutor, sige, mag-conduct kayo ng formal preliminary investigation. Kaya po ngayon, sinabi ni Presidente Duterte na hindi sila magpa-participate, ano? Kaya mabilis-bilis ang takbo ng investigation kung hindi mag-participate si Presidente. Kasi yung prosecutor magbibigay ng notice sa mga persons of interest na nakalagay doon sa investigasyon ni retired prosecutor Basoda. So magbibigay ng notice sa mga persons of interest upang mag-participate sila. Ngayon, kung sasabihin nilang di sila magpa-participate, mabilis ang pagka-desisyon ng prosecutor kasi gagamitin niya lahat yung mga ebidensya na ginamit ni retired prosecutor. Kaya pag makita ng incoming prosecutor, si Prosecutor Kad, na malakas or mayroong talagang probable cause yung mga evidence na sinabmit ni retired prosecutor, ifa-file niya ngayon sa kaso. So, pag sasabihin ng pre-trial chamber, sige, i-file na sa trial court. Di ipa-file ngayon yung kaso sa trial court. Doon, pero dito sa preliminary investigation, kung magpa-participate yung mga persons of interest, they are entitled to counsel. They are entitled to cross-examine the witnesses. They are entitled to examine the evidence gathered by the retired prosecutor. They are also entitled to present their own witnesses. Kaya doon po magtatagal yung proceedings at pwede pang ma-challenge yung bias or prejudice ng mga prosecutors. O pwede pang mag-raise ng legal question. Pwede nilang erase yung sinabi ni Neri on the defense of complementarity. Kaya po at that point, talagang magtatagal. Pero kung hindi sila magpa-participate, medyo mabilis-bilis. So, sasabihin ng pre-trial chamber na judges, 3 sila. Sige, file nga sa husgado and then mano-notify uli yung mga defendants o kung mag-participate sila o hindi. Doon sa trial, kung hindi sila magpa-participate uli sa trial, medyo mabilis ang decision. Kasi isang panig lang papakinggan ng husgado. Yung trial court, it is also composed of 3 judges. At kung walang mga questions of complementarity, walang questions of admissibility of evidence, walang legal issues, then medyo mabilis yung pagkaroon ng decision. Kaya lang, kung mag-participate sila sa trial, ayun, mabibigyan sila ng opportunity for cross-examining the witnesses, for having their own counsel, for presenting their own evidence, and so on, para din yung mga trial natin dito sa husgado. Kaya lang po, mayroong difference between trial dito sa husgado natin at trial doon sa ICC. Kasi yung trial court doon sa ICC po medyo proactive sila sa pag-collate ng mga evidence, sa assessment of evidence, at pagko-question ng mga witnesses. So, that would mean madedelay yung mga proceedings. Pero pag hindi sila mag-participate, then medyo mabilis-bilis yung rendition of decision ng trial court. Ngayon, ang isa pang difference between our trial courts and the ICC trial court is that even hearsay evidence is admissible. Even evidence which would be inadmissible under our courts because it was procured, let's say, by wiretapping or other illegal means, pwede i-consider doon sa ICC trial court. And then, the judges of the trial court can call on witnesses na maski hindi prinesenta ng prosecutor. Kaya po yun, medyo proactive yung mga judges sa ICC. Hindi kagaya yung mga trial courts natin na magdedepende lang sa mga motions ng mga abogado o mga questions and answers ng mga abogado at hindi sila pwedeng maging proactive whether it is for the defense or for the prosecution. Ang pangatlo pong difference yung mga victims doon sa crimes against humanity ay pwede pong mag-participate doon sa trial. They can participate in order to first malalaman nila kung anong katotohanan sa mga nangyayari na nandito before the court. Pangalawa, to seek justice if they were really victimized or their parents, their relatives, their descendants were victims of extrajudicial killings. And then pangatlo, they can seek reparations from the trust fund of the ICC. So, pwede rin silang i-represent ng abogado nila at dito siguro kailangan ng presence ni Attorney Neri at ibang abogado ng mga victims and so on. Then they can seek witness protection para kagaya ng witness protection program natin dito. And then of course, they can calculate their request for payment or compensation from the trust fund of the ICC. Kaya po yung participation ng mga biktima ay medyo active participation din kasabay ng prosecution participation ng prosecutor. So, ayun. Palagay ko po ay medyo mali na strategy yung naisipan ni Presidente na hindi mag-participate kasi ang defense na sinasabi ni Attorney Roque yung element of complementarity. Paano nila ngayon ma-put up yung defense of complementarity sa pre-trial chamber o sa prosecutor o sa trial court kung hindi sila magpa-participate. Kaya po pwede rin silang mag-challenge ng bias ng yung prosecutor or pwede silang i-question yung mga evidence na nakuha ng prosecutor. Baka mali-mali yung mga evident documents na yan o forged yung mga documents. Or they can raise legal challenges. Kagaya yung legal challenge na sinasabi ni Presidente na sabi niya, ito ay mga plano-plano lang ng mga puti, mga white race. Well, actually, that's not original kasi ito yung defense ni President al-Bashir of Sudan nung na-prosecute siya under ICC. Sabi niya, bakit lahat ng mga na-prosecute nanggagaling sa Africa? Sabi niya, ito gawa-gawa lang ng mga puti and so on. Well, anyway, yun po yung mga differences between our trial courts and the ICC. Ngayon, doon sa pre-trial chamber, pag ma-determine nila na mayroon pala talagang reasonable basis to prosecute persons of interest na sinabi ng retired prosecutor, they can issue a warrant of arrest. Yung warrant of arrest po, depende sa gobyerno kasi hindi naman nila maipilit na maaresto yung mga persons of interest dito kung di sila makuha ang cooperation ng gobyerno natin. Kasi nagdedepende lang sila sa gobyerno natin na magbigay visa ng warrant of arrest. Kaya po, kung hindi mag-cooperate yung gobyerno natin na maaresto yung mga persons of interest, wala pong magagawa ng ICC. Kaya po siguro makikita rin natin yung relationship ng itong kaso nito sa forthcoming elections next year. Kasi po kung antipatiko yung mananalong administration sa susunod na eleksyon, baka isurrender nila yung mga persons of interest dito sa ICC at i-revoke nila yung withdrawal ng Pilipinas sa ICC. Kaya medyo do or die. Palagay ko ang attitude ng presidente dito sa elections upang at least yung susunod na administrasyon ay sympathetic sa kanya. So, yun lang po ang masasabi ko ngayon at thank you for listening.
Maraming salamat din, Agabin. Salamat sa pagpapaliwanag ng proseso na inaasahan nating paglilitis. At maging yung tinitingnan nating maaring maging depensa ni President Duterte sa kalaunan. By the way, we're streaming live in Facebook. We're live in the Facebook pages of MovePH, Pinoy Weekly, Karapatan, Kodal Productions, Movement Against Tyranny, Free Leila de Lima Movement, NUPL, and Now You Know. Hinihikayat namin lahat ng mga participants dito sa ating Zoom virtual meeting room at yung ating mga viewers sa Facebook na magkomento at magtanong sa ating mga speakers. Just type in your comments at the comment boxes. Dito naman sa Zoom sa Q&A chat box. Ang susunod nating speaker ay isang bilanggong politikal. Siya ang sasagot sa katanungang, bakit ba ICC ang pinag-uusapan nating larangan? To discuss the failure of the Philippine justice system to prosecute Duterte, we will hear from former Justice Secretary and CHR Chairperson, Senator Leila de Lima. At para basahin ang kanyang mensahe para sa atin, narito si Dean Tony Lavinia. Go ahead, Dean Tony.
Thank you, Josa. Magandang hapon sa lahat. I'm gonna read the input of Senator De Lima. Babasahin ko lang siya. Pero gusto ko lang sabihin na sang-ayon ako sa lahat ng sinasabi ni Senator Leila, kaya gawin ko rin with feelings kasi para na rin salita ko yung mga sinasabi niya. But this is exactly all comes from from her. May PowerPoint din kaming hinanda that can be put in the screen now. No? The title of the input of Senator Leila de Lima is "The Failure of the Philippine Justice System to Prosecute Duterte." Ideally, when we go to the next slide, domestic problems of extrajudicial killings should be resolved domestically, employing our domestic constitutional and legal remedies of criminal investigation and prosecution. However, ironically, it is often the most heinous of offenses that go unpunished. That is, when it is the very same persons or officials who are in charge of defending and protecting the people that are committing acts of violence against them with impunity. Next slide, please. In such cases, when the ideal scenario fails to manifest itself in reality, there remains an international forum under which justice can be achieved if and when domestic remedies fail to provide a genuine solution. Isalin ko lang yon in Filipino. Ang ibig sabihin doon, kung hindi tayo makakarating ng katarungan sa ating lipunan, doon tayo nagre-resort sa isang international forum. Ang tawag nito, International Criminal Court. Going back to the text, the ICC provides such a forum. Thus, essentially, it is an extraordinary remedy available only when it can be shown that domestic justice systems can no longer be expected to provide a genuine solution to end impunity and prevent further acts of injustice. In other words, kung wala na tayong maaasahan sa ating sistema ng katarungan, dun tayo pwedeng lumapit sa International Criminal Court. Ang tawag nito, next slide, please, ay complementarity itong Article 53, paragraph 1A to C, which provides that the office of the prosecutor shall conduct a preliminary examination in order to determine whether there is a reasonable basis to proceed with an investigation into the situation by considering the following factors. Ito yung mga tinitingnan po. Kung may complementarity ba, pwedeng pumasok ang prosecutor. Jurisdiction, yun yung ibig sabihin ng mga crimes na commit ay pasok ba sa Office of the Prosecutor. Admissibility, dito papasok yung complementarity including gravity, and the interest of justice. Next slide, please. Complementarity consists of an examination of the existence of genuine relevant national proceedings. Merong ba mga proseso sa pambansang proseso na tinitingnan yung mga kaso na pwedeng imbestigahin ng prosecutor? Are there genuine relevant national proceedings in relation to the potential cases being considered for investigation by the office, bearing in mind the office prosecutorial strategy of investing and prosecuting those most responsible for the most serious crimes? Yung ICC kasi, ang hinahanap niya kung sino ang pinaka-guilty. So ang hinahanap din nila kung mayroong mga pambansang proseso na iniimbestiga yung pinaka-guilty dun sa krimen na iniimbestiga niya, yung crimes against humanity in this case, no, sa Pilipinas. Next slide. The requirement of complementarity is not satisfied where the state party is able to show that it has taken genuine steps to number one, end impunity, two, encourage genuine national proceedings, and three, prevent the further commission of the crime. Stop lang ko ng konti dito para ma-emphasize natin ang sabihin ni Senator Leila dito, which she got from the statute, the Rome statute. Una, kailangan ipakita ng Estado, ng gobyerno, na talagang pinipigil niya yung impunity, ibig sabihin, hinahabol niya yung mga guilty. Pangalawa, meron talagang pambansang proseso na totoo, hindi lang sham na proseso. At pangatlo, pinipigil na magpapatuloy ang krimen. No? Yung three things na yan. Kung nandyan yung three things, walang complementarity. Therefore, the ICC cannot come in or should not come in. Kasi okay lang ang nangyayari sa bansa. Pabayaan mo yung bansa na marating ang katotohanan o makabigay ng katotohanan. I continue. Thus, before resort can be made to the ICC, it must be shown that substantial efforts have been exerted to the end of conducting a criminal prosecution in the jurisdiction of the state party. Meron bang prosecution na nangyayari, no? And the accused has not been tried because of the domestic legal system of the state party has failed to exact accountability. So tingnan mo na, meron bang trial, meron bang paghahabol ng mga taong responsible, at kung wala, papasok yung ICC. This is because the ICC was established not to supplant the justice systems of the individual state parties, but to complement them. Yun ang ibig sabihin ng complementarity. Hindi siya papalitan, kung hindi, additional siya na procedure kung hindi makakadeliver ng katarungan yung ating sistema. Next slide, please. In such a way, preliminary examination proceedings serve as one of the most cost-effective way for the office to fulfill the court mission. Diyan natin maintindihan na pinaliwanag naman niya din Agabin yung role nitong preliminary examination, no? It's important to understand that in the context of the two goals of the statute, of the Rome Statute, no? The ending of impunity by encouraging genuine national proceedings, and number two, the prevention of crimes, no? Therefore, potentially obviating the need for the court's intervention. At this point, when we go to the next slide, punta tayo dun sa war on drugs by the Duterte government, no? To understand why the preliminary examination resulted in the recommendation or the request for the formal investigation to begin, no? In its 2019 report, this was last up to 2 years ago when they actually updated us, no? When they actually made the request for the preliminary examination to begin, no? The OTP, the Office of Prosecutor, stated that based on open source information, there is indication that a limited number of investigations and prosecutions have been initiated, and in some cases completed at the national level in respect of direct perpetrators of certain criminal conduct that allegedly took place in the context of connection to the war on drugs campaign. In other words, may nangyari naman at that point. The question is, enough ba yun? For example, may sporadic public updates provided by Philippine government officials and bodies on the number of investigations conducted by various authorities into killings that occurred during law enforcement operations. Number two, in fairness, there were criminal charges that have been laid in the Philippines against a number of individuals. Alam natin yon, di ba? Typically low-level physical perpetrator, like in the case of the November 2018 death of 17-year-old Kian de los Santos, wherein 3 police officers were convicted for murder by the Caloocan City Regional Trial Court. So in fairness, ako ito, para matsalin lang, in fairness, talagang meron namang mga ganong klaseng kaso, kaya lang mababang lebelo lang nga ang hinahabol. Alam naman natin yun na may conviction dun kay Kian. Although in principle, only national investigations that are designed to result in criminal prosecutions can trigger the application of Article 17 AC of the statute, out of an abundance of caution, the Office of the Prosecutor also examined national developments that fall outside the technical scope of such term as national criminal investigations, such as the Senate committee hearings into extrajudicial killings. So tinignan naman yan. Ang punto ni Secretary de Lima, and I concur with it, was talagang binigyan ng leeway, di ba? Binigyan ng pagkakataon yung ating estado, yung ating gobyerno, na ipakita na seryoso sila to end impunity, seryoso sila sa investigation, such that even yung Senate committee hearings ay tiningnan. Now, let's go to the next slide, please. Ito naman yung communication ni Secretary de Lima sa ICC on October 9, 2017. Ginawa niya ito to supplement the earlier filed communications of the late Attorney Jude Sabio, of Senator Trillanes as well, and Gary Alejano, Representative Gary Alejano. And there he discussed, the Pahorino grade in Osamis City, where 15 people were killed, the frame-up of Iloilo City Mayor Jed Patrick Mabilog, the smuggling of billions of pesos of shabu by the Davao Group, the one-time, big-time drug operations launched in August 2017, the Caloocan Death Squad, aka the Bonnet Gang, and then the cases of Kian, which we mentioned earlier, Carl Angelo Arnaiz, and Rinaldo de Guzman. I think all are young people. In that communication, Senator De Lima also discussed a situation appropriate to the topic today, which is the failure of the justice system to prosecute Duterte. So she actually discussed in that communication to the ICC what was being done to the CHR by the Duterte regime, no? Yung demonization and attempt to defund the CHR. Actually, isang ako ito, no, pero to amplify lang Justice Secretary Senator De Lima, di ba, yung lost opportunity yon ng national government, ng Duterte administration to prevent an ICC investigation, kung sana in-empower nila yung CHR, kung sana binigyan nila full support, kung sana hindi na tinitira and allowed CHR to do its work, which is doing as much as it can but under very difficult circumstances, then baka na-avoid pa ito, di ba? Because that's a national proceeding also that could avoid at least the ICC's intervention, no? Senator De Lima also mentions the ouster of Supreme Court Chief Justice Maria Lourdes Sereno, and then the failure of the Ombudsman to fulfill its mandate to investigate and file an impeachment complaint against President Duterte. Let me elaborate a bit what Secretary De Lima mentioned about demonization and then undermining of the CHR. With regards to the first, she argues that it is quite impossible to extract accountability in the drug war if the primary institution mandated to investigate human rights violations is undermined, attacked, and maligned at every turn by the highest officials of our government. I think next slide ata yung CHR. Yeah, that's it. Sorry. Hindi kita na cue. But the CHR, this is the truth, no? And I will echo this also as a human rights lawyer working with the CHR in various aspects. No? The CHR is the only remaining credible institution, according to Senator De Lima, capable of holding state security forces accountable for abuses and violations. In light of the fact that other state accountability institutions are under the direct control and supervision of the president, who is the one responsible for the mass extermination program being carried out by the Philippine National Police at present. I'm still quoting from Senator De Lima's communication. No? The CHR was also the very first government institution to undertake an investigation on the Davao Death Squad starting March of 2009. Parenthetically, this was a CHR headed by Senator De Lima then. This was the time when Duterte threatened to line up all CHR commissioners and shoot them one by one before he met them face-to-face in the first hearing on the DDS, which was conducted at the very heart of Davao City. Going now to the ouster of Chief Justice Sereno, with regards to this, the same was resorted to for Senator De Lima in the remote possibility that any impeachment case against Duterte prospers beyond the House, which would mean that an impeachment trial be conducted with the Chief Justice presiding. Ousting Sereno not only enabled President Duterte to install his choice of Chief Justice, but further enabled him to appoint another member of the Supreme Court. And to date, he has successively appointed to such posts justices nearing the age of retirement, enabling him to perpetually keep in play the post of Chief Justice as a bargaining chip. Put simply, it's in this manner that Duterte plugged all the holes and preemptively frustrated and sabotaged any and all legal avenues to hold him accountable under our constitutional framework. Third, again, I read from Senator de Lima, the failure of the Ombudsman. With regards to this, I argued that the failure of the Ombudsman to investigate and file an impeachment case against Duterte actually seals the fate on any domestic remedial measure on the accountability of Philippine Duterte or President Duterte in the drug war killings. No? She quotes, this is de Lima quoting Section 22 of RA 6770 or the Ombudsman Act, which provides said office with the power to investigate any serious misconduct in office allegedly committed by officials removable by impeachment for the purpose of filing a verified completement for impeachment if warranted. The Ombudsman may not have the power to entertain an administrative case or file with the Sandigan Bayan a criminal case against the President, but it has the power to investigate him for purposes of filing an impeachment case against him before Congress. It must be stressed that only the Ombudsman is specifically mandated by any law to investigate and file an impeachment case against the President. Unfortunately, as Senator de Lima stated in her ICC communication, although a complaint for murder has been filed against President Duterte, his son Paulo Duterte, and several other members of the Davao Death Squad, mostly active and retired Davao policemen, such case only proceeded to the preliminary investigation stage after dropping President Duterte from the investigation. If the Philippine justice system is to be capable of proceeding against even the highest officials of the land, the Ombudsman should have followed its mandate, investigated Duterte, and filed an impeachment complaint against him. And this is what accountability of the President under the law and the Constitution consists of, at least in theory, according to Senator de Lima. Instead, what the Office of the Ombudsman did was to completely relieve Duterte from any accountability before any genuine investigation can be done to ascertain the truth of the allegations, including abandoning any investigation of the complaint against Duterte, even if only for purpose of filing an impeachment complaint and not a criminal complaint. The reality is that the Office of the Ombudsman has failed to act in accordance with the power, authority, and mandate to make the highest official of the land accountable for his actions. This demolishes our Republican system by making the President not only immune from suit, but essentially untouchable during his term. And beyond immunity, this is basically the divine right of kings handed to Duterte by the Office of the Ombudsman. I'm going on to the last stage. But before that, siguro summarize ko lang itong sinabi ng sa section na ito ni Senator de Lima. In essence, sinasabi ni Senator de Lima, meron sanang pagkakataon, may oportunidad sana si President Duterte at yung ating mga institutions na i-avoid yung International Criminal Court. No? Actually, it's a very, very insightful itong sinasabi ni Senator de Lima. For a while, many of us were able to say, imposible kasi may criminal immunity si President Duterte, di ba? So hindi talaga pwede criminal. Pero merong impeachment. Di ba? Meron namang impeachment. And the Ombudsman could have initiated that. Of course, Congress could also have initiated that. In fact, there was one that was filed but hindi nila ginawa yun. No? Yung CHR, big opportunity rin yun. Sana na kung pinayagan lang yung CHR, hindi lang siya binastos, hindi lang siya inatake, di ba, na hirap yung CHR to do its mandate and trying its best to do it, hindi pa rin nagawa ng mabuti to deal with this problem, then sana ICC wouldn't have come in. And ganun din yung Supreme Court. Now, we know that Supreme Court, there are pending cases in the Supreme Court na hindi pa rin na-decide, no? Na related to the war against drugs. Last two slides, please. The next slide, please. And I think there's just two more slides after this. Other factors relevant to the prosecutor's preliminary examination, yung DOJ, yung investigation naman ng DOJ, no? I mean, ang sabi ang characterization ni Senator de Lima dito ay sham investigation. As the premier law agency of the Republic, the DOJ has a broad scope of mandate and powers. Through the National Bureau of Investigation is the mandate, authority, and immense capability to investigate complex crimes, such as those allegedly involving state actors, including law enforcement and investigative agencies like the PNP, and other powerful personalities and through the National Prosecution Service, it wields the extremely powerful authority and discretion to investigate and prosecute criminal offenses on its own or through cooperation with other offices like the Office of the Ombudsman. And yet, all that power has been squandered away and virtually rendered impotent to the detriment of victims and their families, in particular of the nation as a whole. That the DOJ from the time of Vitaliano Aguirre is complicit in the drug war is evident in the fact that only a handful of police officials have been prosecuted by the DOJ since 2016. Per sources, out of the thousands of cases of deaths under investigation, aka Nanlaban, reported by the PNP itself, only 52 cases are the subject of an ongoing investigation by the DOJ. In the first place, if the then DOJ Secretary himself does not consider the victims as human beings, I think Secretary Aguirre was quoted in saying that, there is no sense in expecting prosecution from his institution. This policy has been merely continued by his successor Menardo Guevara, with the exception of the UNHRC drama, where Guevara made it appear that the DOJ is finally doing something, even when it still has nothing concrete to show for this drama more than a year after. This belated effort of the DOJ to conduct investigations on a tiny sample of the EJK cases is designed to mislead and falsely impress upon the UN Human Rights Council that the government is doing something to address the spate of EJKs. It is designed to prevent the UNHRC from authorizing the Office of the High Commissioner on Human Rights to conduct an investigation in the Philippine drug war and ultimately to allow those responsible for the bloody war on drugs to continue with impunity and without any accountability. In a sense, the Justice Secretary dog and pony show proved to be successful after the UNHCR backed off from investigation, reducing it into a supposedly mutual cooperation effort between the Philippine CHR and the Duterte government. Again, sa pag-summarize ko lang nito, ang ibig sabihin lang nito na actually magkaroon pa ng one final chance yung government to avert this if they allowed, for example, a UN investigation, cooperated with that, or even with a successful effort to avert that investigation by making the promise to investigate what was happening, they could have averted this again, di ba? But again, hindi siya nakadeliver ng tama, no? Na resulta. Kasi hindi naman tama ang investigation, hindi extensive yung investigation. What can be gleaned from this is that not only is the Philippine justice system incapable of holding Duterte accountable, sometimes even international bodies are too. Of course, the UNHRC is different from the ICC, and that's why we're pinning our hopes on the ICC investigation more than the UNHRC efforts after the latter has proven susceptible to the J of politics of influential countries such as China and its allies in the UNHRC. In any case, this factual backdrop involving the Department of Justice would only enhance the OTP ICC's arguments that the Philippine case has met the requirements of complementarity. After both the Ombudsman and DOJ have shown, it is virtually impossible to hold Duterte accountable for crimes against humanity committed on the Filipino people. Fortunately, the OTP has not been fooled, the prosecutor has not been fooled of the ICC, for it noted that to date, there's appeared to have been no further criminal prosecutions as a result of the initial findings that confirm irregularities in the police handling of war and drugs killings, including failures to observe standard procedures for handling crime scene evidence. The final process that Senator De Lima discusses something, of course, she knows very well, is probably the reason why she's in detention now unjustly. In my view, that's my own conclusion, is a Senate investigation into the extrajudicial killings, which actually she started, no? Even though, and I quote again from her, even though it did not technically come under the definition of national investigations designed to result in criminal prosecutions, the prosecutor also considered the Senate investigation to the EG case related to the war on drugs. Several hearing days were held under De Lima's authority as then chairperson of the Senate Committee on Justice and Human Rights. Unfortunately, the moment witnesses were called linking President Duterte to the spate of EG case, which take after the pattern of the so-called Davao Death Squad, De Lima was ousted from her chairmanship and replaced with a fellow senator, Senator Richard Gordon, according to De Lima, refused to receive further evidence, including the testimony of eyewitnesses to the killings that were to be presented by the Commission on Human Rights. The greatest irony here, according to Senator De Lima, is that after refusing to receive their testimony and evidence, the new chairman released a report stating that there is no evidence that the EG case are state-sponsored, which report was not even circulated to her, Senator De Lima, for her consideration, even as a capacity of as a member of the Committee on Justice and Human Rights. So, Senator De Lima, according to her, filed her own dissenting report and sought to memorialize the testimony of the witnesses who were denied their opportunity to testify and speak their truth under oath. Again, according to Senator De Lima, the pattern is discernible. Whenever there's a genuine attempt to investigate and hold those responsible accountable under national proceedings, something happens to derail the investigation and make any attempt to hold anyone genuinely accountable is rendered impotent, thus defeating the two overarching goals of the statute, which is to end impunity and prevent further commission of similar offenses. Final slide. In closing, I'm reading from Senator De Lima's intervention again. She would like to summarize the conclusions of the Office of the Prosecutor in its preliminary examination report to the pretrial chamber of the ICC for purposes of requesting an authorization to proceed to the investigation of the Philippine case. The prosecutor noted in his report that there was a failure to take steps to investigate or prosecute EG case in the drug war, aside from Duterte promising immunity for the murderers. The prosecutor quotes Duterte saying that even if the police or army massacre 100 people, he will pardon and promote them. Sorry, may isang slide pa pala. Final slide. The OTP also noted that out of the thousands of EJK cases, only one case has proceeded to judgment, which is the case of Kian. Senator De Lima quotes the Office of the Prosecutor in this, and I quote that too. It appears that only a handful of token cases focused on low-level physical perpetrators have proceeded to trial. There is no information to indicate that any individual has been investigated for ordering, planning, or instigating any killings. Senior commanding officers implicated in killings have been temporarily relieved of duty and later moved or even promoted. The minimal prospects for accountability in the Philippines for alleged war and drug crimes are underscored by the two Senate committee hearings on the war against drugs, concluding with accusations of whitewashing, as well as Duterte refusing access to the territory of the Philippines for an investigation by the UN Special Rapporteur on extrajudicial summary or arbitrary executions. All this considers ATP to show that the OTP was never in a rush to find the existence of complementarity and proceed with their own investigation. In other words, talagang thorough ang investigation nito sa issue na ito on complementarity. The OTP gave, the Office of the Prosecutor gave the Philippine government ample opportunity to resolve the crimes under their own system of domestic remedies. But in every turn, the Duterte administration sought to defeat our own legal system from genuinely ending impunity or enforcing accountability and preventing state actors from perpetrating further atrocities. Ultimately, what this means is the requirement of complementary has been satisfied, at least for purpose of requesting the pre-trial chamber for authorization to proceed with the Philippine investigation. Thank you po.
Maraming salamat din, Tony. Salamat sa pagpapaliwanag sa atin ng principle of complementarity, maging yung mga nilalaman ng mga ICC communications, kabilang na yung mga i-file ni Senator De Lima, at yung nilalaman ng OTP report to the pre-trial chamber na pagpaliwanag ng iba't ibang insidente ng failure of the Philippine criminal justice system na pawang sumasalamin naman sa kawalan ng pananagutan o lack of accountability at impunity sa ating bansa. Ngayon naman pakinggan natin ang grupo ng mga mamamayan na pinakaapektado sa ating lahat. Sila yung mga kaanak at kapamilya ng mga biktima ng EJ case ng war on drugs. To discuss what these cases mean for victims of Duterte's war on drugs, narito si Nanay Lor Pasco Benedicto ng Rise Up for Life and Rights. Go ahead po.
Si Leila Pasco, ina ni na Crisanto at Juan Carlos Lozano, na biktima ng giyera kontra droga ng rehimeng Duterte. Isa ako sa libong biktima na naghain ng reklamo sa ICC, International Criminal Court. June 14 ng taong kasalukuyan, kami ay nagsumiti muli ng karagdagang dokumento kasama ang mga biktimang sumisigaw ng katarungan sa halos 5 taon na ngayon. Nagpapasalamat kami sa ICC, Prosecutor Madam Fatou Bensouda sa pagbibigay halaga at pagkilala sa aming hinaing mula pa noong 2018. Siya ay magre-retire na ngayong June 16. Mapalad kami dahil ginawa niya ang lahat, pinag-aralang maigi ang mga dokumento upang magbigay sa amin ng pag-asa na makasilip ng liwanag sa matagal na naming minimithing hustisya. Sa kasalukuyan po, ito ay panibagong paglalakbay at hamon na pag-aralang muli ng bagong prosecutor ang aming sinumiting dokumento. Sa ngalan ng mga biktima, kami po ay umaasa na pag-aralan muli ang aming kaso. Hangad po namin ang hustisya para sa aming mga mahal sa buhay. Bawat pamilya, nanay, anak at asawa na pinaslang dahil sa giyera kontra droga. Alam natin na napakahirap at mailap kamtin ang hustisya dito sa Pilipinas. Bilang mataas na respeto sa bagong uupo na prosecutor, kami po ay nakikiusap at humihiling na sana magkaroon ng hiwalay at malayang investigasyon dito sa Pilipinas upang sila mismo ang makasaksi sa tunay at totoong mga nangyayari sa ating bansa. Kahit po sa panahon ng paghihirap dahil sa pandemya, wala ding maayos na programa ang gobyerno para sa mga pamilya ng mga biktimang pinaslang higit lalo sa mahihirap. Sa kabila ng ganitong kagutuman, bingi ang gobyerno at patuloy pa din ang patayan. Gayon din ang talamak na bintahan ng droga sa komunidad na galing sa mga matataas na taong kilala sa lipunan. Nananawagan kami sa iba pang mga biktima na lumabas at lumahok sa mga gawain upang magsalita ng bukal sa kalooban hinggil sa katotohanan. Panahon na upang kamtin at ipaglaban natin ang karapatan tungo sa hustisya. Maraming salamat po muli sa pagbibigay ng pagkakataon na mailahad ko kung ano ang katotohanan. Kaya't ating isisigaw, itigil ang pamamaslang, katarungan, ipaglaban. Maraming salamat po. Mabuhay kayo. God bless you all.
Maraming salamat. Natunghayan natin ang isang video presentation ni Nanay Leila. Salamat po sa pagbabahagi ng saloobin at karanasan ng mga biktima at ang pamilya ng mga biktima ng giyera kontra droga. Ngayon naman, nakarating na tayo sa huling bahagi ng ating programa, ang Question and Answer Open Forum, at marami na tayong natanggap na katanungan sa ating Q&A panel dito sa ating Zoom room. Meron ding mga pinadalang katanungan via email at iba pang paraan. So simulan na natin. It is said that the ICC may not hear and try crimes against humanity in absentia. The ICC itself has no international police to execute warrants of arrest. Also, Duterte himself declared he would not cooperate with the ICC. The non-cooperation of Digong means no PNP, no NBA agents to arrest him. Question: how can we bring Digong personally to ICC for proper trial during his incumbency? This is from Diosdado P. Estimada of Baliwag University. Siguro pwede nating itanong ito kay Dean Agabin, Attorney Neri, and Dean Tony. Meron pang related question, basahin ko na rin kasi this also pertains to arrest.
Okay,
When would an arrest be effected on Duterte? Pag nag-trial na or upon conviction? Go ahead, Dean.
Actually, arrest can be effected pag nag-decide na yung pre-trial chamber na ifa-file ang kaso sa trial court. So, antayin natin na mag-decide ang pre-trial chamber na magsabing okay, agree kami doon sa recommendation ng prosecutor, kaya ifa-file natin yung kaso sa husgado. At that point, pwede na silang mag-issue ng warrant of arrest. Ngayon, kagaya yung sinabi ko kanina, kung hindi magko-cooperate ang gobyerno natin, hindi pwedeng ma-aresto o ma-effectuate yung warrant of arrest. Kaya nakapending lang yon, pero hindi effective.
Yes, yes, agree ako kay Dean Agabin. Siyempre, kailangan mag-issue ang ICC ng warrant of arrest. So kung mag-issue ang ICC, and in fact under the ICC parang may 45 proceedings ngayon na under 25 proceedings na ang ICC ngayon, may mga warrants of arrest na na-issue dyan. May mga at large, parang kung if I remember right, ang at large ay 16, no? Tapos may iba dyan, out of the 45 proceedings na nilunsad ng ICC, may iba dyan na kakulong na, iba dyan na tapos na nga ang sentensya, etc. Doon sa pag-investigate, pwede bang mag-issue ang ICC ng warrants? Investigation stage pa lang naman. Ang sabi sa Rome Statute, in exceptional circumstance, pwedeng mag-issue sila ng warrant if necessary, halimbawa ang accused ay continuous commission of crimes, so para ma-stop ang pag-commit ng crimes. No? Second, to assure the appearance of the accused of the respondents sa trial. At pangatlo ay pag sinisira o ang ebidensya o yung proceedings ng korte ay inaatake ba. So those are the possible chances ng tawag diyan pre-indictment warrants. Pero syempre mas trial talaga ang mag-issue ng warrants kasi para yan ang pinaka-sure na provision diyan. Paano siya ma-arrest kasi ayaw niya mag-cooperate? Well, during his incumbency, kung ayaw ipatupad, halimbawa may warrant na na-issue, paano ipatupad yun dito? Ayaw mag-cooperate? Well, mahirapan nga, sabi ni Dean Agabin, kasi wala namang huhuli sa kanya dito. Pero pag bumiyahe siya sa ibang bansa at doon ay may mga bansa, halimbawa, na willing i-implement yung warrant, pwede siyang arestuhin doon. No? Nangyari yan sa isang kaso kay Pinochet, hindi sa ICC ito, pero a long time ago kay Pinochet na dumaan sa London, no? Diktador yan ng Chile noon. Ngayon, pwede namang hindi siya, so limited na yung travel niya. Siguro kung sa China lang siya pumunta at mga kaibigan niya naman ang mga doon, hindi siya aarestuhin ng China, lalo na't hindi naman miyembro ang China ng ICC. No? Pero yun, medyo mag-ingat na siya sa pagbiyahe. Pangalawa, syempre, ang bagong presidente sa 2022, at ako man tingin ko bago ang presidente sa 2022, hindi na Duterte. So, siguro ang bagong presidente may allow the execution of the warrant here, no? At sabihin ng bagong presidente, rule of law tayo, may international court na nag-issue ng warrant, we have to respect that, di ba? Pwede bang mag-cooperate ang isang bansa na hindi na siya miyembro ng ICC? Yes. Under Article 93 ng Rome Statute, pwedeng mag-cooperate ang isang bansa kung gusto niya kahit hindi siya miyembro. So pwede parang ma-effectuate yung warrant during pendency pag mapunta si President Duterte sa isang bansa na willing siyang arestuhin. And secondly, pag natapos na yung termino niya at ang bagong presidente ay hayaan na ang warrant ay ma-execute dito, pwede rin siyang ihulihin dito at isurrender siya sa ICC. Salamat.
Ang dagdag ko lang, emphasize ko lang kay Dean Agabi na sinabi kanina na, di ba sabi niya na parang mali yung strategy ng Duterte government, di ba, in terms of not engaging dun sa ICC. Actually, mas mapapabilis yung arrest pag hindi sila mag-appear, halimbawa, di ba? Because then pwede warrant of arrest can be issued just for them to appear, no, yung summon. So parang gano'n, mas while kung if they go through the whole process, mas matagal yun kasi syempre bibigyan ng chance yung anong ebidensya na isubmit nila, anong argument nila on complementarity, lahat yung gano'n. So yan ang irony dyan, di ba? Kaya ako, ang advice ko talaga, lalo na dyan naman si Harry Roque, who's an expert on the ICC. Actually, you have very good ambassador now si Ambassador Admiral is also very good, very professional, no? Good friend of mine. He will do the right thing on this professionally. So parang they have a better chance appearing rather than not appearing, di ba? In terms of the warrant of arrest. So feeling ko dito mas mabilis mang issuance ng warrant arrest sa pagde-deadman nila ng ICC. Pero tama din scenario about the implementation, maraming challenges, may options, may possibilities, pero maraming challenges. Historically, talagang mabagal siya historically. Even in the special tribunals, 'di ba, dun sa Bosnia halimbawa, sa mga iba-ibang Kosovo, mga iba-ibang mga special tribunals sa Rwanda, ngayon sa under the ICC, talagang sometimes it can take 5 to 10 years before you can bring someone. Pero sa totoo lang, eventually the long arm, di ba, of the law and the justice reaches you in some form or another, di ba? And sometimes it will just be history that will make the judgment pag ganon, but the judgment will still be made.
Very well said. Thank you, Dean Stoney, Dean Agabin, and Attorney Neri. I hope you don't mind sa ating mga participants na nagpadala ng kanilang mga katanungan that I'm asking questions per topic and trying to collapse related questions together. So my next question is from Sir Ted Rehencia and Ms. Rosalinda Apostadero. So even with the withdrawal of the Philippines from the ICC, the government can still participate in the possible investigation and trial if President Duterte changes his legal strategy. And 5 years into the Duterte drug war, do you think that the policy is a failure? And the last question is, tanong ko lang po kung allowed po bang tumakbo si Duterte sa 2022 election gayong may kaso siya. Salamat po.
Well, if I may give a short answer, una, sa tingin ko, hindi siya allowed magtumakbo sa election. At pangalawa, the drug war, is it a failure? Definitely, yes. Actually, inamin ni President Duterte yan sa SONA niya of 2018, na sabi niya it failed. Kaya akala ko, sasabihin niya sa SONA niya, so let's go back to the drawing board. Nagulat ako yung ending niya, the drug war will continue as ruthlessly as before. Kaya, so failure. Actually, kung marami na nagtatanong sa dinami-dami ng patayan, ano bang nagawa nun? May nasolusyonan ba talaga yon? Parang gumaan ba ang buhay natin? Gumanda ba yung ating ekonomiya? Parang andyan pa rin ang corruption, andyan pa rin yung droga, andyan pa rin ang krimen. Parang walang nangyari doon after all the thousands of deaths. So, klarong-klaro na failure talaga yon. At si President Duterte, hindi incompetent talaga siya, hindi lang sa COVID, pati yung kanyang mga ideya sa crime prevention, hindi rin nag-work, no? So, ano nga yung first question ulit na first part ng first question? Tatlo kasi.
Yes, yung... wait, I'm looking for it. Oh no, nawala po sa ating
okay.
Q&A. Okay, ito po. Ito. I'm pulling it up, sabi dito. So even with the withdrawal of the Philippines from the ICC, the government can still participate in the possible
Okay.
investigation.
Yes. Kasi accused siya. Pag accused ka, whether member ang state mo o hindi, akusado ka. So you have all the right to participate in the trial. At agree ako kay Dean Agabin at Dean Tony, not only because they're my deans sa College of Law, kundi because good tactic talaga yan na mag-participate ka. Kaysa sa i-claim mo yung isang walang kakwenta-kwentang depensa, walang jurisdiction, wala na kayong withdraw na kami, yung mga walang kakwentang-kwenta, hindi naman na-publish yan. Talagang talo lahat yan sa ICC eh. Papapabilis lang yung warrant of arrest dyan. So mas mabuti mag-participate kayo at para may due process naman dun sa ICC para mabigyan kayo ng chance na magdepensa kaysa sa ganito lang ang mga depensa nyo. Talagang pag may warrant of arrest na darating ang panahon na aabutin ka ng hustisya. Salamat po. Thank you.
Okay, thank you. Yung susunod pong mga katanungan may kinalaman pa rin po sa pag-aresto. So I will read them together. This is from XC Medea. May prescription period ba yung warrant? If ever, friendly pa rin kay Duterte ang next government. Di pa ba from Edwin Egar, di ba siya pwedeng arestuhin ng mamamayan? And from Joseph Leroy Garcia, what are your individual assessments when the ICC will issue a warrant of arrest on Duterte and other EJK perpetrators? Dean Agabin, Dean Tony?
Yung Dean, ikaw muna.
Yeah. I'm afraid that an ordinary citizen may not muster enough courage to arrest even an ex-president. No? So the ICC relies on the governments to effect the arrest, even if we have already withdrawn from the ICC. In fact, there is one situation where even the countries like China or US or Russia may effect an arrest. And that is where the United Nations Security Council refers the case to the ICC. And the ICC renders an adverse decision. Even the non-member countries can arrest him on the basis of the United Nations Security Council transmission. Salamat po.
Thank you.
Yeah,
Yes, Dean Tony?
yung dagdag ko lang doon, yung arrest warrants, wala siyang prescription, di ba? As long as the moment is issued, it will subsist until it is executed. So hindi yan magiging issue namin I think ang magiging issue is whether may change of circumstances sa Pilipinas that will allow the arrest to happen, no? Ang sagot ko dun sa question naman na anong assessment ko, I'm reading the objective lang, no, reading the request. Parang malinaw na mag-grant siya, di ba? I think the request will be granted, and then if in fact magpatuloy yung pagdedma ng Duterte camp, they do not send a lawyer, they do not respond, di ba? Yung ganung klaseng they will not cooperate. ganito kasi ang ano dyan, pag mag-cooperate sila, then they have to allow the investigators to come, etc. Di ba? So if they don't cooperate, pwede sila ma-issuean very early on, di ba? ng arrest warrant. Remember, hindi lang ito si President Duterte, there might be others implicated, di ba? Certainly some names are already in the may mga pangalan ng iba na nabanggit sa report. So confident ako sa stage na 'yon. What happens after, frankly, historically, it's all domestic after that. Ano bang, di ba? Ano bang may change of circumstances ba sa bayan that will allow the arrest to be effected, di ba? Sa totoo lang, walang makakapag-predict niya ng mabuti kung ano talagang mangyayari doon.
Thank you. Next question po natin has to do with procedure, availability of documents about the complaints filed with the ICC and the indictment. Number 1, available po ba online yung filing sa ICC? And number 2, is the President the only person liable in the indictments? What about others who have facilitated the crimes?
Well, kung ang tanong ay yung pag-participate ng victims, available siya online. There are 2 ways for victims to participate. At una, online, meron dyan sa under the Victims Protection and Reparation Section, VPRS. At pwede rin kayong mag-mail, snail mail or email, no? Merong mga ganong ano. Ngayon, sino ang pwedeng magsulat niya ng mga biktima? Ang desisyon ng prosecutor, ang those who are mga murder or other crimes ang nakalagay doon from 2011 up to March 16, 2019. So any crime na commit doon in relation to or to the war on drugs, pwedeng pwedeng biktima na isampa doon. Generally, may time limit ito. Dapat 30 days from notice. Pero nagsabi ang ICC sa kanilang notice na we will give you the deadline in due course. Pero kung ang mga biktima ay gusto mag-participate na, dapat sana handa na before July 15. Just in case na 30 days ang notice, no? So, iyon yung ang sasabihin lang naman ng mga biktima doon, we comment nila, we agree with you, we support halimbawa the decision, the recommendation of the prosecutor to open an investigation. At bakit? Bakit? Kasi tatay ko, yung kapatid ko, yung anak ko ay pinatay, ganito, pinatay ng ganyan. So anything na medyo related sa war on drugs or yung ginamit na dahilan. I remember ang Negros Oriental ata na sila General Sinas when the people there were executed in the implementation of the search warrant. Ang sabi ng Cebu noon, drug campaign yun eh. So can they also file as victims ang Negros Oriental, kumbaga massacre? Pwede naman kasi ang warrant, lalo na pag sinabi officially ng police na drug case ito. So yun yung mga para sa mga biktima na willing mag-participate.
Yes.
Okay, thank you. Our next question is from Mr. Bob Moran. Aside from affidavits of victims and their families, will there be hard evidence presented in the form of videos, audio recordings, and official documents that would give more weight to the case? In Marites Vitug's sui generis letter this week regarding such cases, a lawyer who successfully defended a number of international defendants in the ICC said that such evidence would be critical for a successful trial.
Yeah, the more, the better, di ba? Better quality, better quantity. But what I've noticed, I don't think there's going to be a problem for that, Bob, because if ever itong killings na ito were done on, di ba, openly and with media right after, and I want to comment on kasi sabi media lang daw on source, but media here were actually witnesses because they came right after the killing or just when the killing was happening. Di naman ito na report lang nila. They were really participants in the process of all of this was happening. So tingin ko maraming ganyan. Sa tingin ko, the documents are actually all out there. There was a there's a pending Supreme Court case on those documents. So hindi naman nakatago doon. May smoking guns ba? Maraming smoking guns even in those documents. I think you can also, this is just from reading between the lines no, sa OTP report, yung mga redacted portions, parang malinaw na they actually have good evidence already of the nature na binabanggit ni Bob, including evidence that they preserve. Remember, it turned out na na ready na pala sila to make the request. The OTP was ready to make the request in December 2020. So 6 months ago pa, ready na. And they actually made the request 1 month before they told us, diba? By late May, or 3 weeks before they told us. And I think somewhere there, nagsabi sila na or in an interview, the OTP said that they had to wait lang kasi they had to preserve the evidence, diba? So I suppose that means providing protection to witnesses, making sure that the documents or videos or whatever audio and video documents they have are able to be preserved properly, and di ba yung ganung klaseng So I'm actually kind of confident this will be one of the cases that are in the ICC that's going to be the most documented ever. Kasi I've been following crimes against humanity since the Balkans pa, because I had friends in the old Yugoslavia that were affected by that. So it was very personal to me to follow the killings in Bosnia, in all of those places. And ang hirap i-prove siya kasi kailangan talaga testimony lang dahil wala naman mga videos noon, wala naman tayong mga cellphones noon, di ba? And if you kill everyone, di ba, who will be, unless meron kang informers, di ba, yung ganung klaseng But this one is all the killings, most of the killings here were done in front of family, di ba? In front of So I think we should encourage all the family members to use the yung online, yung website na to give their testimony, to give whatever they have, the cell phone pictures that they have, whatever they would remember seeing. Kasi I hope this will be the most documented crime against humanity ever. Importante yun regardless of whether may arrest, how it ends, but it's important for history. It's important so that it's not repeated again, di ba? That ma-document natin ng mabuti in a legal way. Noon pa man sinasabi ko, kailangan pag mag-document tayo, even now we do it in a way that is legally, di ba, usable and relevant. And I think media people have actually done it this way, whether intentionally or not.
Dagdag ko lang kay Dean Tony, tama si Dean. Hindi totoo na hearsay, sabi ng Malacanang, kasi nakita nila mga media reports. Ang media reports doon, binasa ko yung mga footnotes. Doon, in fact, nag-i-interview sila ng mga whistleblower, kumbaga, mula sa police, mula sa vigilantes. So ako, may prediction ako na mayroong mga whistleblower from within na mag-testify sa ICC kung matuloy yung trial. Secondly, tama rin si Dean, libo-libo ba naman ang pinatay mo? Daan-daan yung mga eyewitness dyan. Sigurado yan sa akin. At ang testimony na yan, napaka-importante yan. So, yes, it will be. By the way, doon sa mga gustong mag-register doon sa ICC na biktima, confidential yon unless you consent. So, ang inyong report sa ICC ay maging confidential. Of course, unless you consent na, sige na, hindi ako takot, di ba? Pero it's confidential. So assurance yun na hindi malalaman yung inyong testimony until the trial, of course, ay mangyari. Salamat po.
Thank you so much. So that answers the question about the availability of documents kasi confidential po yung pagtrato sa mga dokumentong ito. So unless the victims who filed are willing to furnish the public copies with their complaints, hindi po natin siya ma-access publicly from the ICC website. Pero buti na lang shinare ni Attorney Neri na other victims and victims' families are welcome to register sa VPRS section. Naka-post na po ang link sa ating chat box. Okay, so malapit na po matapos ang ating panahon. So I can probably ask 2 more questions This is from Sol Iglesias. Sabi niya, has there been any formal or informal reaction to the ICC prosecutor's recommendation from usual human rights allies such as the EU, particularly the European Parliament? How will the transition to a new ICC prosecutor affect the Philippine case?
Well, ako wala akong alam na reaction. Hindi ko nabasa kung merong reaction. Gobyerno, ibig niya sabihin, no? EU, gano'n, no? Pero yung mga human rights groups, syempre, may mga statement na yan, no? In support of that, no? So, yeah. Ano ang last question? Ano yung marami? Ano yung last question?
How will the transition to a new ICC prosecutor affect the
si Prosecutor Khan is not a stranger to human rights and IHL violation. In fact, bilang Assistant Secretary General ng United Nations, involved siya doon sa commission to investigate the war crimes in Iraq. So hindi yan. And in fact, I read na napunta siya sa Pilipinas before to lecture here among the kaya very familiar talaga siya sa kaso. In fact, if I may say so, mas familiar siya tingin ko kaysa kay Prosecutor Bensuda. Kaya I don't see any reason bakit mahirapan si Prosecutor Khan in investigating this. Of course, I'm sure he's going to be fair, he's going to be objective, but yung background knowledge niya sa nangyayari dito, very, very wide yan. At in fact, ang background knowledge niya sa investigation ng mga crimes against humanity or war crimes for that matter, extensive din yun. Very well-known human rights lawyer, si Prosecutor Khan. And I don't think puti siya, by the way, as President Duterte wants to say. At in fact, marami sa mga judges doon ay hindi puti. In fact, marami doon Africans, may Mexican, may mga Asians. At of course, ang Dean dati ng College of Law, si Dean Agabin, Asian yun.
Yeah.
Dean Pangalangan. Sorry, Dean. Si Dean Raul Pangalangan is definitely Asian. Filipino pa.
Yeah.
Yes, thank you.
In addition,
sige po, Dean, go ahead.
Just,
Apa.
if the president and the other persons named in the investigation do not participate, the new prosecutor will have no choice but to file the case. Kasi nandun na lahat ang evidence. At kung walang contrary evidence, wala siyang choice kung hindi file yung kaso Kaya nga sinabi ko kanina, mali yung strategy na the president will not participate.
Yeah.
Thank you.
Agree.
Thank you, Dean. Meron po tayong katanungan dito na ang tingin ko ang best person to answer will be Nanay Leore kasi kasama po natin siya ngayon pala, bagamat nagpadala po siya ng video kanina. The question is, what can be done? Nanay Leore, pakisagot na lang po pagkabasa ko. What can be done now by ordinary citizens concerned with EJ case in the country to put pressure on ICC to approve the request of the ICC prosecutor for a full investigation? Ano po yung pwedeng gawin ng mga ordinaryong mamamayan na nagmamalasakit sa mga kapamilya at biktima ng EJ case sa oras na aprubahan ng ICC yung request ng prosecutor for a full investigation? Go ahead, Nanay.
Well, actually, Joseph, the citizens
Naka-mute po kayo, Nanay.
can persuade the heirs of the victims and the relatives to register their participation and so that the evidence will be collaborated by the testimonies of relatives and heirs of the victims. Thank you.
Thank you, Dean. Nanay Leore?
Well, para po sa amin, sa mga biktima, dahil talagang kami po ang lubos na naapektuhan, kahit naman siguro hindi ko sabihin sa kanila kung ano yung dapat nilang gawin, willing talaga sila na mag-participate kung ano man dahil lahat kami gusto namin ang hustisya para sa aming mga mahal sa buhay. Bilang isang coordinator ng Rise Up for Life and for Rights, marami rin po kaming Ngayon, marami po kaming trainings, marami po kaming mga inaaral din po namin lahat yan, na kung paano po namin ma-reach out ang mga iba pa pong biktima. Yan po ang aming gawain ngayon, gagawin, para po makakalap pa rin po kami ng mas marami pa pong mga ebidensya. Kahit po marami na talaga kaming ebidensya, mga video, mga testimonies, pero gusto pa rin po naming abutin po yung mga iba na hindi pa, kumbaga, hindi pa nila masyadong naiintindihan itong kung paano itong kalakaran ng ICC at kung ano yung mga patakaran. Kaya ano kami po, hands-on po kami para ipaliwanag, para kumbinsihin, at kunin talaga ang kanilang opinyon na tunay namang totoo para po maging malakas at maliwanag para po dito sa kaso na ito, na para maging matibay na ebidensya laban dito sa hindi lang kay Pangulong Duterte kundi sa kanyang mga excuse me po, sa kanyang mga allies na gumawa nitong mga krimen na ito. Yun
Salamat,
po, maraming
Nay.
salamat po.
Nay, meron pa pong humabol na katanungan.
Sige po.
Marami po sa pamilya ng biktima takot magtestigo sa piskal at korte. Kung sa ICC po ba ay may takot pa rin? Paano po yung mga takot?
Dati po yon, dati po talagang nung mga siguro po, mga una at pangalawang taon, marami po akong nakakausap na takot talaga po sila dahil sa mga nangyayari, at lalo na po itong ibinaba na po itong anti-terror bill na naging anti-terror law. Doon po sila natatakot. Ang sabi nga nila, ano ba yan? Para bang bumabalik yung panahon ng martial law. Sinasabi nila yun sa akin. Pero siyempre pinapaliwanag ko sa kanila na habang tayo ay nagtatago sa takot, lalo tayong tatakutin. Kaya sabi ko, kailangan natin yung puwersa. Sama-sama tayong lahat para labanan itong nangyayari ngayon. Dahil tayo yun tayo yung apektado, lalo na tayong mga mahihirap. Para matagal man kung darating ang hustisya, pero makakaasa po tayo na magkakaroon. Kaya kami po lahat, umaasa po kami doon. Natutulungan po kami ng ICC dahil sa marami na rin po kaming na isubmit na mga supplemental documents, sa tulong rin siyempre ng ating mga magigiting na NUPL lawyers. Kaya yun, malakas ang loob namin. At kami rin po ang nagpapalakas ng loob ng mga iba na medyo pa sila, alanganin pa. Yun.
Maraming salamat, Nay. Sana po nabigyan po natin ng lakas ng loob yung iba pang mga pamilya, kaanak ng mga biktima para sila ay lumitaw din at lumapit sa ICC. Kagaya po ninyo. Okay. Dito na po nagtatapos ang ating programa. Pasensya na po dun sa mga nagpadala ng mga katanungan. Pero hindi po natin natanong kasi kinapos na po tayo sa oras. Pero bago po tayo magtapos, bigyan ko ng konting panahon yung ating mga speakers para mag-iwan ng mga huling salita bago po natin isara ang programa. Let's start with Dean Agabin, followed by Dean Tony, Attorney Neri, and finally Nanay Leore. Go ahead, Dean.
Well, actually, mayroon din isang prinsipyo na hindi masyadong maraming ebidensya against the President. Ito po yung tinatawag natin command responsibility. Kasi sabi po ng isang eksperto, si Professor Harry Roque, who is my good friend, sabi niya na the President can be held liable under the principle of command responsibility at sinight pa niya ng kaso ni Yamashita. Of course, sinabi ni Hari ito noong hindi pa siya spokesman ng presidente. Narinig ko lang ito noong nagle-lecture siya he was advocating ratification of the Rome Statute nung nagle-lecture kami sa Philia. Kaya po hindi ko makalimutan yan kasi lahat ng alam ko sa ICC naririnig ko lang kay Hari. So yun lang po ang masabi ko.
Dean Tony.
Yes.
Thank you, Dean, again.
Actually, gusto kong sagutin yung as my final words, yung tanong ni, I think, Mitch Santos about paano yan kung 5 to 10 years pa ito, mamamatay na si President Duterte. Una lahat, hindi natin alam yon, di ba? Tulad na hindi natin alam na mamatay si Pinoy last week, di ba? So parang that's not an issue kung kailan mamatay yung tao. Importante that the march of justice goes on. And we follow that to where it will go. As I said, di ba, we try to do justice in the world. In this case, kung wala na siya, then it will be through his, di ba, the other people accused with him, but we have some closure because of that. And then, kung hindi man lang dan, may kasaysayan, may Panginoon, di ba? So parang we don't have to worry about that, to be honest. Importante na the march of justice continues.
Well, sa akin, the struggle may be long and hard, but the lawyers of the victims and the Filipino people will really make sure that accountability wins out in the end. And President Duterte will get the punishment he so richly deserves. What if the struggle is long and hard? Well, if the struggle is long and hard, that's how struggles are fought. And that's how struggles are won. So sa akin, tuloy lang ang laban. Ang importante lang, nasa tama ka, nasa katarungan ka, at nasa katotohanan ka, tuloy ang laban. Maraming salamat po.
And finally, Nanay Leore.
Maraming salamat po sa pagkakataon na binigyan nyo kami ng ganitong pag-uusap upang ilahad kung ano talaga yung nasa aming kalooban. At gaya nga ng sinabi ni attorney na tumagal man yan, abutin man yan ng dekada, lalabas pa rin at lalabas kung ano yung totoo. At parurusahan kung sino talaga yung may gawa ng mga kasalanan. Yun po. Maraming salamat.
Maraming salamat sa ating mga speakers ngayong hapon. Dean Agabin, Dean Tony Lavinia, Attorney Nery Colmenares, and Nanay Leore Benedicto. On behalf of the Movement Against Tyranny, Rappler's MovePH, Rise Up for Life and Rights, Free Leila de Lima Movement, Karapatan Alliance for the Advancement of People's Rights, papasalamat po kami sa lahat ng participants sa ating webinar ngayong araw. Maraming salamat po at sana'y magkita-kita po tayong ulit.
Salamat. Maraming salamat.
Salamat po.
Congrats. Congratulations. Yes, thank you. Thank you.